austerity and everything. Welcome to USD Sociology, Supreme Court Spotlight Panel discussion on the Students for Fair Admissions Incorporated, the President and Fellows of Harvard College, and Students for Fair Admissions Incorporated versus the University of North Carolina cases. Before we get ourselves started, I'd like to thank the Opportunity Center at USD, the Office for Multicultural Affairs, Department of Political Science, Criminal Justice Program, Anthropology Program, Department of History, Philosophy Program, the College of Arts and Sciences, and the School of Law for their assistance in publicizing our event this evening. We're going to begin our event this evening with a rousing discussion by our esteemed panelists, of which we have 4 this evening, though I think that those of y'all on Zoom might sort of be able to see the heads of 3 people, as opposed to actually seeing the people there. We'll move to Q&A after about 30-40 minutes. I'm going to ask everyone to please hold any questions or comments you might have until the end of the panel's discussion period. I promise we're going to get to questions, and you'll be able to provide questions both if you'd like, either through the text box on Zoom, or you're welcome to certainly provide them directly as well. So without further ado, I'd like to begin by introducing our panelists for the evening. On screen, on Zoom, we have Peter Arcidiacono. Dr. Arcidiacono is an American economist and econometrician. He received his PhD in economics from the University of Wisconsin-Madison. Following the completion of his PhD, Dr. Arcidiacono began his employment at Duke University and is still there today, currently serving as the William Henry Glasson Professor of Economics. Dr. Arcidiacono is known for his research contributions to 3 fields: affirmative actions in higher education, structural estimation of dynamic discrete choice models, and college major choice. He has also published work on peer effects, racial discrimination, the minimum wage, and marriage markets. His expertise in many of these aforementioned areas led to him being hired as an expert witness for both of the cases that we are here to discuss today. Also joining us is Dr. Sean Kammer. He is a professor of law at the University of South Dakota. He teaches courses on natural resource law, environmental law, torts, minerals and energy, legal history, advanced legal writing, and foundations of law. His research focuses on public lands, the wilderness, legal profession, as well as legal history. He's published work on whether or not special expertise is required in the courtroom, addressing anti-intellectualism, the Supreme Court, and the legitimacy of law. Prior to joining the USD law faculty, he taught natural resources law courses at the Lewis and Clark Law School in Portland, Oregon, and legal history at the University of Nebraska. A graduate of Duke Law School, Dr. Kammer also earned his PhD in history from the University of Nebraska. Also with us this evening is Dr. Sandy McKeown. Dr. McKeown is an associate professor of criminal justice at the University of South Dakota. She's also the coordinator of the criminal justice program and faculty ombudsperson at USD. Dr. McKeown teaches courses on juvenile justice, ethics in criminal justice, trial and evidence, criminal prosecution and defense, criminal justice and legal writing, constitutional law, criminal prosecution and defense, writing and research in criminal justice, as well as criminal law. Her research focuses on courtroom language interpretation, trial advocacy, legal practice and practitioners, as well as constitutional law. Prior to joining the criminal justice faculty at USD, Dr. McKeown earned her JD from the USD School of Law and her Bachelor of Science in Political Science from USD as well. During her tenure at USD, Dr. McKeown has been the recipient of the Blair and Linda Tremere Professorship in the Arts and Sciences, as well as the Belbis Larson Award for Excellence in Teaching. Last but certainly not least, we have Scott Pohlson here with us. Scott is the Vice President for Enrollment, Marketing, and University Relations here at the University of South Dakota. He has served in this position since 2014. Vice President Pohlson has accumulated nearly 2 decades of experience within the student enrollment industry and has also served as the Dean of Enrollment at USD between 2010 and 2012. In addition to serving USD as Vice President of Enrollment, Vice President Pohlson currently serves as the board chair for the Vermilion Area Chamber and Development Company. He earned his MBA in Business Management from Creighton University and his BA in Economics from Coe College. I don't really need to introduce myself. I'm just going to be your moderator for this evening. Okay, I see somebody making a face at me. Yes, I am Dr. Isaiah Cohen. I am better known as Yesh. I am an assistant professor of sociology here at USD, and I will be your sort of maybe esteemed moderator for the evening. I will do my best, no promises. But with that all said, I'd like to ask Dr. Arcidiacono to please explain your involvement in the cases at hand before we proceed to questions.
Great. So I was hired by Students for Fair Admissions to examine admissions data both at Harvard and UNC. My view on this is that a lot of my work has been on affirmative action in higher education. And so, but I've always found that to be very dissatisfying because you never have the data you need to actually do the analysis. Universities guard their data tightly. So what they hired me to do, though, I got a chance to see Harvard's admissions data, which was quite the opportunity. And they hired me to examine in Harvard whether Asian American students were discriminated against relative to white applicants, and also how large racial preferences were for underrepresented minorities. In UNC, there was no claim of Asian discrimination. So my role was to focus mainly on estimating the size of racial preferences. There was another part to the case which I had limited involvement with, which is that Supreme Court has sort of said you need to pursue race-neutral alternatives when possible. And so there was another expert for SFFA designed to evaluate whether there were reasonable race-neutral alternatives available to Harvard and UNC.
Thank you very much. I truly appreciate it. We're going to get ourselves started off with a relatively interesting question, because I would imagine that at least some of those in attendance may not know a ton about the specifics of the Harvard and UNC cases. So I'm going to pass this question out to the panel to please just generally describe the facts of the case for both the Harvard and UNC cases, and in particular, how they might be similar and different.
Well, I'm certainly happy to jump in. One of the big differences is on the Asian discrimination front. And that there, a lot of the debate was over how it operates. So one of the cases was that they have what's called a personal rating. Sort of remarkable the way Harvard's admissions process works. One of the things they have is a personal rating, and that Asian Americans, in my view, did inexplicably worse on. That was one aspect, and then the other aspect was the way racial preferences operate. And what you'll see both in Harvard and at UNC is that it operates in sort of an odd way. You get you do get a large bump. The largest racial preferences are for African Americans. But the bump that you get depends on whether you're disadvantaged or not. And Harvard, they actually have a thing for where, saying the admissions officer's view on whether you come from a disadvantaged background. And basically, you get a large bump if you're African American, you get a small bump if you're disadvantaged. But if you're African American and disadvantaged, you don't get the disadvantaged bump. And that holds true at UNC as well with regard to first generation college status. The other sort of interesting thing about UNC is the way that racial preferences operate differently depending on whether you're an out-of-state applicant or an in-state applicant. So racial preferences are actually much larger for out-of-state applicants than in-state applicants. And there are various explanations for why that might be the case.
Okay, so to potentially open this up a little bit more in terms of some of what we're going to be focusing on this evening, what are, and certainly the Harvard and UNC cases, they're very clearly similarities, but you also have a private university versus a case involving a private university versus a case involving a public university. So what are the legal issues that are to be decided in these cases in your estimation?
I can start on that, I guess. Oh yeah, is this? Yeah, okay. Yeah, I mean, I would just say and this relates to, I guess, the last question as well as this one. That it's notable that the Supreme Court, the issue it granted cert on, so the issue it's actually deciding as a legal matter, is whether to overrule this 2003 case called Grutter v. Balmer. Yeah. So it really consolidated the two cases to minimize the factual distinctions, and it's really deciding a legal matter as to whether affirmative action is legal. And while ultimately the facts might end up mattering, and the specific distinctions between them and all of those very well might end up mattering, as to the Supreme Court, its decision and what it will be deciding in this term is really whether race can be considered at all. So, and for both these cases, that's issue number one, is the Supreme Court is being asked to overrule now decades of precedent. And then the second issue differs based on the state versus private distinction and the actual legal hook for plaintiffs. In the Harvard case is entirely statutory, is entirely the Title VI of the Civil Rights Act. Whereas in the UNC case, they've got the Constitution, which guarantees equal protection of the laws and applies to states. Harvard is not a state. UNC is, as part of North Carolina, is a state. But really, I think the legal issue, the Supreme Court's been very upfront that the legal issue is, did the Supreme Court get this right? In a string of cases going back to the 1970s. And that's what the Supreme Court has told us it's going to decide. And then ultimately it might decide it got it wrong for narrow reasons, in which case very much the factual distinctions will matter. But at least in terms of what the Supreme Court has told us the issues are. And I think I believe this, the Supreme Court in this case. In very recent history, we've seen the Supreme Court overturn precedent where it didn't say it was that was the issue, and it surprised us. Here it's telling us very much we are considering whether to overrule over 40 years of precedent regarding race-conscious admission. And
Okay, so I think, yeah, I think it's really, it's not insignificant that they took the case and that they asked the parties to address this question of whether Grutter versus Bollinger can continue to stand in light of, like, equal protection analysis. I think it's really a pretty good indicator that the court is very seriously considering walking away from precedent, which would mean that universities such as Harvard wouldn't be permitted to consider race at all in admissions. And I think one of the reason why the court had previously said that it was constitutional for schools to consider race had to do with the school's interest in having a diverse student body. And this is a compelling interest for a number of reasons. That, the whole idea of just making sure that you have variety of voices in the classroom, the importance of the university's First Amendment rights in terms of academic freedom in choosing who their student body is, and the conversations that they want to have in classes and things like this. This is going to be, I think, another one of those cases where everybody gets rocked back on their heels a little bit by the court.
I know a lot of our audience isn't legal, maybe. Yeah, so the Greta v. Bollinger case is, I think I said it's 2003. I think that's right. And there are actually two cases from the University of Michigan. And the Greta v. Bollinger case is University of Michigan Law School. And that's where the court confirmed, I guess, this test that says that promoting diversity and promoting a diverse student body for the sake of a more rigorous and better student experience, as well as promoting better academic quality, is a compelling purpose for a state to pursue, and that using race as one factor in admissions is narrowly tailored to that. So it sort of confirmed what had been questioned from a case from the 1970s, where there was a very much mixed opinion as to whether that was the case. So it sort of solidified this rule that yes, you can survive either under the Civil Rights Act or under the Equal Protection Clause. You can survive having race-conscious admissions policies if your goal is a diverse student body to promote a better student experience and learning experience, and to promote, you know, the academic pursuit of truth and knowledge and those things. And so long as you're not having racial quotas, it's narrowly tailored. And that's the precedent that the court is very much indicating explicitly, when it's not always explicit, that it's reconsidering. So that's what's on the line.
So when we think about what it means to be narrowly tailored, I think that's where that's probably all in the eye of the beholder. You know, the history of these cases, it keeps looking like they're limiting it, but then nothing really ever changes. You know, if we think about those Grutter and Gratz decisions, I'd be curious to hear what you guys think about this, but I actually would have preferred, if one case was going to win, I wish it would have been reversed, so that the explicit point system where all the preferences are on the table, and then we can have discussions about that, works a lot better in my mind than the hiding of how things operate. And that's where I think when things are more explicit, you know, I think one of the side benefits of these cases is, you know, understanding how legacy preferences work. You know, when you think about athletic preferences, we think about that being like an equalizer. Well, at Harvard, it's not an equalizer. Harvard has more varsity sports than any school in the country. And the primary group that benefits from athletic preferences are whites. And that's because, you know, the marginal sport is something like sailing. So, you know, in my mind, I would much prefer to have things, you know, transparent on the table. And I think I really feel that way in light of more the polarized world that we live in, where, you know, if you're on one side, you think racial preferences are way bigger than they are. If you're on the other side, you think the racial preferences are way smaller than they are. If things were just much more transparent, might lower the tension a little bit.
I think I'm just going to kind of speak a little bit from the administration perspective of this, like from the admission side. So what we're also looking at from these particular cases is what, and it's not probably fair, but what I'd term elitist institutions. So those are institutions that have what is not considered to be an open access admissions policy. So when you think about policies at which I would argue a lot of the public institutions that are open access are a lot more transparent about that for obvious reasons. We're not limited in the number of students we can take to a certain extent in certain programs. So you see with like USD, what we call or statements as opposed to and statements. If you look at a lot of these different policies, and good point that a lot of them aren't very transparent, right? And especially at private institutions that are elite, that becomes even more difficult to really jump into. So it's kind of fascinating if you look at some of the data that you actually worked on, and I'm looking behind, but you can't see me. It is cool or interesting, I guess, to kind of see that. So from my perspective, I think like even the University of Michigan case, a lot of this comes down to obviously like the equity and access and affirmative action side of things. And one thing that will happen, in my opinion, is if race is not allowed to be a factor, there are certain factors that will lead to improving access. So if it's not a race indicator, it'll be things like, well, it'll be based on needs. So those that have lower, let's say EFCs, those might be families that have a higher propensity to come from a more racially diverse background. So there will be alternatives that a lot of these institutions, in my opinion, will just revert to, which is listed in a couple of different examples of what race neutral actions are that they can take or review. But I do think what it comes down to is there's never really been a scrutiny over it, and there's never been a transparency to it. And so the legal argument is an interesting one. I think it's also interesting to talk about transparency and really what is fair and equal. And that's tough in the context of the legality of these cases. So that's kind of my perspective.
I apologize. I just want to ask, since several people in the room likely don't know what an EFC is, could you just briefly explain what that is for our audience, please? Thank you.
So when I said EFC and FAFSA, that's what you file with the federal government, which is the free application for student aid. And then the EFC is the estimated family contribution, which is a federal methodology from the FAFSA that tells you what the federal government believes to be the fair price that you would pay to go to college. And I'll leave it at that because no one agrees with what their estimated family contribution comes out to be. It's always higher. It's like, it's kind of like what you're going to pay for taxes. No one ever agrees with those either.
Sorry, go ahead.
I just want to talk for a second about what the affirmative action policy actually is, and why it's in place. I mean, the reason why these institutions have created affirmative action policies that allow them to consider race in admissions is because historically they did consider race, and it was to prefer white students for admission, right? And so there are historic injustices that need to be addressed, especially with regard to educational access. Look at the Supreme Court. Where did those guys go to school? And now women. They went to Harvard and Yale. They went to these schools that gave them access to the levers of power in the United States. And historically, minority populations have been excluded from those levers of power. And so when institutes of higher education are looking to address those historic discrepancies, there, that's kind of one of the impulses of affirmative action. Now, the U.S. Supreme Court has been very clear that they're only going to accept certain reasons for allowing this type of what is arguably, I mean, this word is probably not right, but making distinctions between races, right? And I think that the organization that brought this lawsuit, they referred to it as discrimination, and they believe that in particular Asian American students are being discriminated against at Harvard. The way that Harvard says, at least in its litigation stance, that it looks at admissions is what they refer to as sort of a holistic review. And this is what the Supreme Court has indicated is going to be what passes constitutional muster. In other words, race is not supposed to be a deciding factor. You're not supposed to separate out minorities to only compete against one another, right? You're supposed to look at the whole student. And so what Harvard says that it does is they look at academics, they look at extracurricular, they look at whether the person is involved in athletics, and then they have what's already been referred to as the personal rating. So this personal rating is like this looking at, and you guys know this, you've seen, they're looking at things that the students has done, I think things about them like their leadership qualities, what they've been involved in. And then there's almost this ambiguous, like what special are you bringing to the table? And it is in that part of the analysis that the plaintiffs are arguing the discrimination is occurring. And with regard to the preferences that Harvard gives, the first huge preference goes to athletes, children of Harvard alumni, children and relatives of large donors, and children of Harvard faculty and staff. So one of the things that the plaintiffs have argued is that you haven't considered race neutral alternatives. In other words, quit giving legacy admissions to all of these students, right? Quit giving admission just because somebody, gave a big donation. Well, Harvard responds that these aren't necessarily workable solutions, right? You want your alumni, look, if you're Harvard, you want to increase your foundation, right? So you want your alumni to love you and give you money. And not only that, but all of their legacy admissions are not necessarily from white families anymore, right? Because they've had a more race conscious admission standard. And, athletics, so you go to USD, the primacy of athletics at an institution and the importance of being able to recruit people to come and play. And then the children and family members of large donors. Well, again, it's money, right? And so the argument here is that these are alternatives that are potentially on the table, but they are not necessarily going to improve, racial diversity in the student body. They're not necessarily going to fix the problems that the plaintiffs have pointed to in terms of what's going on or what they perceive to be going on with Asian American students. And they're actually in the long run going to hurt Harvard. So that's the factual argument that's being had here. Is that?
Yes, just a few comments on that and the previous comment. When we think about the way the admissions operates, and we think about what it means to say race is a factor of a factor or one of many factors, I really think that is in the eye of the beholder. So I basically found that affirmative action at Harvard quadruples the admit rate for African Americans, and my counterpart found that it triples it. So it's pretty large. On the personal rating front, I think that's it. I find that thing really disconcerting what Harvard did there. And I say that for a few reasons. One, imagine a place that says, look, it's not that we're not hiring this particular race, it's just that they scored poorly on our likability rating. And they didn't have to provide any evidence that connected to anything. That just, in my mind, provides sort of a blueprint for discrimination. And the reason I really truly believe this is discrimination is, one, we actually do have personal ratings from the alumni interviewers who actually rate them much better than the admissions officers do on the personal rating. And the difference between the alumni interviewers and the admissions officers is they actually meet the applicants. And the remarkable thing is, like, if you look at in UNC also had a personal rating. And Asian Americans did just fine as whites on UNC's personal rating, where they're not discriminating against them. But I really do agree with you that something needs to be done about the racial inequities in this country. The reality is, like, had admissions been based solely on academics, about 1% of Harvard admits would be African American. That's a train wreck, and that is something that desperately needs to be addressed. What I'm concerned about relates to the comment about, this is an elite university issue. And I think that that's right. I think it provides a Band-Aid to cover up dealing with really serious issues that need to be addressed. It makes it seem like we don't have a problem here when we really do. But I definitely take the point that there are certain things, like Supreme Court justices, where you almost have to go to those top Ivy League schools in order to get there. So anyway, I probably talked too long.
No, you didn't. Yeah, I mean, I think the fundamental legal issue here is really what equal protection means, right? And what equal protection laws means, what equality means in this country. And one of the things I think the Supreme Court has gotten wrong, even in its line of affirmative action cases, is treating alleged discrimination against white applicants or white people the same as discrimination against Black or other minoritized groups. And it raises the question: is the goal of the 14th Amendment to dismantle the remnants of racialized chattel slavery, or is it to require the government to pretend, at least in its explicit forms that it puts out, that race doesn't exist? Right, and I think it was Justice Brennan in the 1970s case that Farrell out of California, the Bakke case, where he said color blindness cannot lead us to myopia, right? That it can be a form of just blindness, right? And it can perpetuate some of these systemic racism issues. And if we're following the Supreme Court in some of its holdings recently, where it talks about the importance of historical tradition, I don't know how you read out of the 14th Amendment the context of the Civil War and the 13th, 14th, and 15th Amendments as dealing with not just race consciousness, right, and requiring the state to at least explicitly not recognize the existence of race, but to actually deal with the institutions of white supremacy and the remnants of racialized chattel slavery. And that's, and I think, there's been this tension in the last 40 years where the Supreme Court's kind of given some weight to this notion of color blindness and this concept of reverse racism and discrimination against white people and all this stuff. And I think that's been a mistake. And now I fear the Supreme Court's going to double down on that and really distort at least what was the original understanding and original intent of the 14th Amendment.
Given the direction that we seem to kind of be going with our conversation, I think it makes sense for me to bring up a question that we'd come together to bring to y'all. So, broadly speaking, are affirmative action and other diversity, equity, and inclusion, also known as DEI-inspired policies like those at Harvard and UNC, do you consider those to be socially desirable for society or not?
I know this might not be, I don't know who's listening to this, but yes, I mean, yes, yes. The history of systemic racism in the United States is so deeply rooted and so pernicious and so damaging to people who have grown up in generations of discrimination that there needs to be some way to affirmatively address it. And to ignore the fact that race plays a role in every law that's on our books, that race plays a role in the decisions that the Supreme Court makes, and that those decisions and that those rules have historically oppressed parts of our country, but just consistently and persistently, our structures are built in a racist manner. So if we are refusing to address it, then what we are going to do is just continue to persist with what we've done historically, which means we're not moving forward in terms of protecting all American citizens so that they have equal access to things like education and jobs and other types of opportunities. So my answer is unequivocally, yes, they are a good thing.
So for me, the devil's in the details. There are definitely good things associated with that. I think that the tension I find is how the policies get targeted, and does it take our eyes off of dealing with deeper issues? So when we think about access to Harvard, one study showed that 40% of the Black students at Harvard were not descendants of slaves. They were first or second generation immigrants. And I see the way the policy works. I like the way things are set up in a place like Brazil much better. So the way it works in Brazil is you're going to get a bump if you're going to a public high school, and you're going to get another bump if you're going to a public high school and you're a minority. And I feel like the tension that I find here is that the policy is not targeting, it's not targeting the people who we would like it to target. One of the things I found very frustrating after the murder of George Floyd was, at Duke, suddenly we had all this attention on how Duke was racist. And there may be ways that Duke is racist, but it takes, in my mind, took the attention off of what I thought was a much bigger issue, which is the big issues are where things are really bad is among the poor, among poor minorities. And that, I don't think affirmative action at these elite schools is doing much to address that. Is it better than nothing? Probably. But even then, I know that I'm involved in this court case where it gets presented in the binary, but part of the reason I wanted to take the case is I feel like the discussion on affirmative action is always centered on that binary as opposed to what would be the optimal amount. How would we think about designing this program to really help to target it to the right people? And then to, is there a point where we think that it could possibly go too far? And then our universities, my feeling is I would have much less of an issue with affirmative action if I felt like universities did their job. But I feel like what they do is they admit these students and then don't support them and don't provide them with good information when they're there. At Duke, we actually asked for the data to see, how could we help minority students succeed more in our major? And at first, the university wanted to give us the data, and then they stopped. That seems insane to me. They're more worried about covering themselves than actually, doing things to support the success of the students. That's my frustration with some of the way the programs operate. But there are other programs I think, are very good and we should be pursuing.
So interesting point of clarification. I should have known about Brazil's, but I don't know about all these bumps. So did you say that Brazil, you get a bump for being in a public and a bump if you're disadvantaged? Is that what or did you say diverse? What did you say?
You get a bump if you're going to a public school, and then you get another bump if you're a public school and you're a minority. That's my understanding of how it works.
That's kind of I think that's an interesting point of clarification from, again, my role from an enrollment perspective. What's the difference between that and what your data showed that you get from an affirmative action standpoint? It actually does help in Harvard's situation to get the bump in the structure in which it is. What are you saying the difference between those two are?
Oh, the difference is it's the biggest advantage of affirmative action goes to more advantaged African Americans. So you get a big bump if you're Black, you get a small bump if you're poor, but you don't get the poor bump if you're Black. That's what's so weird. They treat Blacks monolithically. Whereas what I would say is that the Black students who I most want to see get the preferences are poor Blacks, not the rich ones.
Interesting.
I'll answer in the affirmative to the question if I still remember it. And I think part of the discussion here too kind of has to be on admissions in general, right? And And, you know, this notion of affirmative action as a racial preference, I think is a framing that is controversial, and I would disagree with it, right? It's not expressing a preference for minoritized candidates or applicants. It's not expressing a preference for Black applicants. It's merely recognizing that the other criteria that are typically used in admissions do not represent the full, you know, the full person, right, of the applicant, and don't necessarily produce the best student body, both in the individual sense and in the collective. So I think to represent, you know, the ACT test or the SAT test as if there's some objective measure of quality of an applicant, I think is a framing that lends itself to a certain conclusion as it comes to affirmative action. So I'd push back on affirmative action as expressing a racial preference. And you know, if you look at the numbers in North Carolina, I think their percentage of students that are Black is still less than 10%. In North Carolina as a state is over 20% Black. So if you say that UNC is expressing a preference for Black applicants, it's not showing up in the numbers. And affirmative action is a recognition that there is this systemic racism that is embedded in the other criteria, including these so-called aptitude tests that have been shown to be problematic as well. Yeah, so that's a point I would make, and I think the point is well taken that the programs could be better designed, and that universities might use them and then, you know, as sort of a band-aid and not really address larger issues. And I definitely see that point, but in terms of the benefits of affirmative action, I think absolutely they're not only beneficial but necessary to this university environment.
So just give some context on what I mean by universities not supporting their students. What's been interesting, like, I think the reason I got hired for this case was in part a paper that I wrote that caused a little bit of controversy, but the controversy is really over a data fact. At Duke, African-American men and women come in wanting to major in STEM fields and in economics at the same rate as white men and white women, but they were leaving at a much higher rate. And so among Black men, it was really striking. 58% of Black men who started in STEM or economics switched to another major versus 8% of white men. You didn't see much. Duke will figure out a way to graduate you, but there was this big switching behavior. And that switching behavior, once you account for differences in academic background, sort of goes away. So that, and you know, when we think about UNC not being representative, I think the problem runs deep, and we focus so much attention on this affirmative action at the college level when so much damage has been done by inequities, you know, much earlier than that, which I mean, we just have to address those.
I absolutely agree. Like in terms of, you know, universities completely failing to live up to their diversity and inclusion statements. We see it everywhere. That's absolutely true. My concern with the conversation of we got to move on from affirmative action so we can address these more serious issues is that affirmative action is like the first step Like you have to open the doors in the first instance, right? If the doors are never opened in the first instance, then to me, it just seems like you're just ignoring the initial problem or trying to paper over the initial problem by saying, but look over here at this awful thing that's going on too. It's all bad and it all needs to be addressed. And my argument in response would be saying that the Constitution is colorblind doesn't address any of that. All it does is sweep all of it under the rug and ignore the fact that we have historic inequities. And part of the issue in this case, and it's the government, or not the government, excuse me, it's Harvard's litigation stance that, despite the claim that its admissions process is discriminatory against Asian American applicants, there isn't evidence in the record of any Asian American student that was denied admission because of or lost a seat by a less qualified other minority candidate. And so I guess to me the litigation feels a little cynical.
Well, the litigation is certainly, without a doubt, the purpose of litigation was to face affirmative action. That I think is clear. I think it's impossible to show whether one particular candidate would be the one who replaced another. It's just statistically, that's just not possible to do. The file that haunts me, because I actually read a bunch of the admissions files, and one has just stuck with me. This is the one that makes it hard for me to sleep, was an Asian American female who applied, and her dad had a severe mental illness. She spent some time in foster care, and her and her mom got hit by a drunk driver the summer before her college applications. And in each of those things, it's almost crazy how many things happened to this poor girl. And she describes each of these things in her essays. The teachers talked about them in the recommendations. And the alumni interviewer says, this is one of the best interviews I've ever had, and gives her very high marks on the personal rating. And then you look at what the admissions officer comment was on the file, and the only thing that they wrote was SS. And what SS means is standard strong. Good, but not good enough. The file's not going to get another read. And she got the same score. She got the usual personal rating score, like what everybody, just average. That's the thing that drives me. I read the files. I saw how they talked about the Asian American applicants. In my view, what I was most disappointed in with the ruling, we can have many people have differing opinions on affirmative action. But what I thought was not good is I thought they should say, look, the judge could have said, look, we can keep affirmative action, but you cannot be penalizing Asian American applicants relative to white applicants. She could have done that separately and basically said, stop downloading the information on whether you're Asian or white. You will still have it for African Americans and Hispanics. And basically treat it the way Harvard treats religion. So what happens with religion actually shows up on the Common App, and Harvard doesn't download that field. And the reason they don't download it is because of what they did to the Jews. The main difference between how they handled Jewish applications then versus Asian applications today is that they were just much more explicit about it. There you can actually get the quotes that says, we don't want those too many Jews. You don't see that. That's not in the records. You see it from one of the donors to Harvard who expressed concern with how many Asian Americans they saw. But there was, I think what bothers me is I think had this case been brought by somebody who wasn't tying it to affirmative action, if it had only been about Asian Americans relative to white applicants, this would be a landslide. I don't think my counterpart in the Harvard case even takes it. But because these things ended up being inextricably linked, I thought I guess the cases got screwed in the process. Because then they ended up, saying, oh, in order to justify affirmative action, you have to justify discriminating against Asians relative to whites. I think it's just disappointing that that's how things evolved with it. I understand why it did, but that's my frustration.
But what was the evidence that Asian Americans are being actively discriminated against in this process? I mean, I recognize that that's a very sympathetic file that you point out, but I'm having a hard time connecting that to the race of the candidate.
Well, so the reading the file just confirms what my statistical analysis showed. And the only way, I mean, you can make an Asian penalty go away by making a series of bad decisions. In my view, on the economic side. So, one, every model that I estimated with the personal rating showed that Asian Americans were being penalized in it. And whatever controls you put in, you would always see that. Well, that's one mechanism of discrimination. As soon as you pull that out of my counterparts' models, any of their models, it shows a penalty against Asian Americans. But there's other ways in which that's not the full extent of the penalty, in my view. And I should say, my intent was always to get papers out of this. And so I've actually turned these things into what are peer-reviewed publications. And that's not true of my counterparts. But the other big debate was, how do you handle those applicants that you mentioned earlier, the athletes, the legacies, the children donors, children faculty and staff. And what I will say is that there is not discrimination against Asian American athletes or Asian American legacies. That's a little over 2% of Asian American applicants. But when you put those, so if you just said, you see clear penalties when you look at applicants who are not one of those special groups. Coming from Duke, it's really clear why that would be the case. The idea that our basketball player, that race had anything to do with their admissions. No, they got in because they're an amazing basketball player. But the problem is that when you include these other groups, and this is basically what the judge said. The judge said, well, why would they be treating them differently, Asian American applicants differently, because they're legacy? Well, I totally disagree with that. Of course, legacies get treated differently. Race is going to matter differently for those. It's not Asian American legacies that are going to suffer. It's the 97% who are not in that group. To me, it'd be like saying, well, in football, we don't see discrimination against the defensive line, so there must be no discrimination against black quarterbacks. That's crazy. So to me, I actually came about it more from the statistical side, and that work is peer reviewed, and my preferred estimate shows that it's roughly about 20 percentage point penalty for being Asian American relative to white applicants.
So I had a question that, not to put you on the spot, Scott, but I guess kind of to put you on the spot. What is USD's stance on the utilization of affirmative action or diversity indicators when evaluating admissions applications at USD? If you can respond.
Yeah, it's not there. Simply put, we're an open access institution. That's what I mean. I totally appreciate the discussion. It's fascinating to me, but it's also why I totally appreciate the fact of being at an institution where the variables are how do we educate the masses as opposed to, and I hate to say it this way, but like more of the elitist folks. That's so it's I've said that for a long time. Maybe it's because they never let me in. I grew up in a small town in Iowa called Grinnell, Iowa, and there's a college there. And so I saw a lot of this as a child. My parents aren't in academia. So I was the air quotes townie. It's just fascinating to see some of these institutions with how that's why I appreciate the fact that statistically speaking, it's interesting because I think what you're saying, and I apologize, I didn't read that piece of this, that the advantage comes when the personal review is done, correct? And then that's the disadvantage to the applicant. Am I kind of dumbing that down a little bit?
Yeah, I mean, there's a few aspects. They got the personal rating, but then, you know, how disadvantage operates in the process.
And that to me is where, when you introduce at these selective institutions, the reviewers' ratings, there is a human factor to that. And they worked really hard. There's a recent book out by Jeffrey Selingo, I think is his name, about like kind of the inside aspects of elitist institutions and selective institutions. It's fascinating just to kind of see the process of how the rater, how that plays into whether or not the selection of the student is there. I mean, like for us, it's straightforward. It's a mandate from the state of what exactly we're going to do. We have the ability to make exceptions for 3% of our total admit pool. But to be honest with you, when you're an open access institution, making an exception means everybody gets in. And for the most part, everybody gets in. So it doesn't play a role for us. I think where our institution and other public institutions like us, where this decision will start to impact us, is on scholarships and whether or not there can be preferences set when you're selecting a scholarship recipient, and what factors race can play in those particular decision bases. That's where I say there's always unintended consequences to these decisions, right? And I think everybody's brought that up, is that when it's an affirmative action case and the court is making that decision based on that particular fact, it then switches to, well, now there might be that unintended consequence of like less diversity in some of these top ranked institutions. And that just seems to be counter to what we're trying to do. Although an interesting fact about the fact that it does disadvantage them when you introduce these different factors. So I don't know. I think that's what's tough about this.
So and I appreciate your response there. Oh, did you want to go ahead, Sandy? Sorry.
I was just going to add that I think another impact on an institution like USD is that if the Supreme Court comes down the way that I kind of expect they will, we're going to start having this conversation again about the Constitution supposed to be colorblind. And this, I think, is problematic. That type of language puts us into a position where we are just refusing systemic racism. That is already a problem at institutions like USD, and having the sort of stamp of approval from the Supreme Court for that type of attitude, I think is tremendously problematic, particularly, you know, for example, in our state. I mean, the obvious underrepresentation of Native Americans in higher ed, like these are things that we need to be actively working on. Not only for minority communities, for the community as a whole. Like everybody benefits when we're pulling everybody along with us.
Okay. I'm sorry again, Sandy. I appreciate you being understanding with me, accidentally almost cutting you off. I apologize about that. And I really appreciate both of your responses, because you're kind of already getting at a question I was starting to look to ask everyone. And it seems we've kind of partially answered this, but since these cases are not being decided jointly, they are being decided separately. Due to the recusal of one of the justices, they're going to hear oral arguments, I think on the same day, if I remember correctly. I think on Halloween, we're hearing oral arguments for these cases, but for both cases. But with that in mind, what are your predictions for the outcome of each case? And I guess to extend that, we've kind of already touched on this a fair bit. What practical implications might these possible or predicted outcomes have?
I got handed the mic. I hate predicting the Supreme Court, but I've gotten to be pretty cynical. Yeah, I mean, I think this has been a target for what we might call the conservative legal movement. since it started, and if we date that to say the founding of the Federalist Society, who's basically become the gatekeeper for Republican appointed judges, federal judges, and ultimately stepping stone to the Supreme Court. Like, this is one of 2 or 3 targets, another of which was reproductive rights. And there are a lot of people saying before Dobbs that, oh, they won't overrule Roe and Casey v. Planned Parenthood, and I wasn't sure what they would do, and I tried not to make predictions, but I was like, I think they will. They will in effect, if not explicitly, and as I mentioned earlier, in that case, the Supreme Court seemingly went out of its way to not signal that, right? And the politics in the court is interesting, and it takes 4 to decide to hear a case, and the overruling of Roe v. Wade and Planned Parenthood v. Casey and all the other cases wasn't even on the table, and that ended up being the result. And I just think they've got their ducks in a row now, and they're gunning for for all of the foundations of the civil rights movement, and certainly that includes affirmative action. And so I'm not optimistic, and I guess I'm up here as a lawyer, right? But I don't, the law is almost irrelevant, right? It's about power, and who has the power, and who's those who are in power, if they're willing to exercise it. And I think the Supreme Court has no qualms about exercising power. And in this case, it would be, for the sake of I guess white grievance, right, or white backlash to the civil rights movement, which has been a long time coming. So I hate to be on the record like this, but I mean that's my prediction, and I guess I hope to be surprised, but I don't have a lot of faith in this Supreme Court at all. So, and I don't see what they're doing. Maybe going beyond what I should be saying, but I don't see this court having much legitimacy as a court, to be honest. And I don't see what it's doing as being a matter of law at all. So that's my prediction.
I definitely don't feel any comfortable making any predictions on what the Supreme Court will do. I will say, I think there are competing visions, and that it doesn't have to necessarily be set up that way in terms of, how do we get to a more equitable environment? I'm going to share an unpopular opinion, which is I think Clarence Thomas gets a very bad rap. We think about Clarence Thomas, and you think about maybe 2 things, well, maybe now 3 with his wife, but conservative and Anita Hill. A book I would highly recommend people read just to understand where somebody like him is coming from is My Grandfather's Son, which talks about his history here. And, I read that book when I was at Hilton Head, South Carolina, on the beaches, and he was describing the segregated beaches. And we may disagree, people may disagree with what he sees as the solutions to these things, but I think it is to say that he doesn't care about and doesn't understand how racism operates. Certainly his own words in the book would really beg to differ. And So I think, yeah, I think that's probably all I would really say about, where things stand. Oh, what I meant to say, I guess one last thing on that was, he is perhaps the poorest guy to ever become a Supreme Court justice, which is something I didn't know. It's my grandfather's son because he's basically starving when he gets dropped off at his grandfather's house. And, to me, one of the best proofs of racism is what gets said about a guy like him. We disagree with how his rulings and such. But what I found interesting, one of the things I most appreciated about the Supreme Court before was the friendship between Scalia and Ginsburg. And if you read what Sotomayor has to say about Clarence Thomas, Justice Sotomayor talks about what a good person he is and how he treats others. And of course, she completely disagrees with him about all the rulings. But I just want to move more towards an environment where we can disagree in love, I guess.
I would just argue that the reason why we know about Justice Thomas and his history and his beliefs about affirmative action is because he went to Yale. I tend to agree with Professor Kammer about how things are going to turn out. I think for people who would like to see affirmative action higher ed preserved, I think the case where there's the closest glimmer of hope is probably the Harvard case, and that's because that depends on statutory analysis. The court, if they overturn, if they find differently in this Harvard case than they found in previous cases, then they're going to have to make the argument about why they. So I should say, what the court typically says is that if the legislature disagrees with the court's interpretation of legislation, then the response is a legislative response, right? If that's not how we should interpret Title VI, then amend Title VI, right? And Congress didn't amend Title VI. And so now the court, if they're going to give the petitioners the win on the Harvard case, is going to have to explain why the interpretation of the statute has now changed without any kind of congressional sort of intervention. What I would say, I guess from my personal perspective as a teacher and somebody who, I don't know, just as a teacher and somebody who is here at USD, is that no matter where the court goes, I don't think that you can turn the court into the court or bigger issues or those issues over here, or those issues over here. I don't think that's where we turn our attention if we want to address systemic racism. I think we address it where we are. And so regardless of what the court has to say about these issues, we all still have an individual responsibility to acknowledge the systemic racism exists and take actions in our personal sphere to try to address it and adjust it. None of those justices have control over, the decisions that you make with regard to how you try to address systemic racism as you see it in your community. And I think it becomes even more important for us to be proactive about that in light of a court that seems to maybe not necessarily agree that it exists, or at least the current majority doesn't.
All right, well, since we're hitting about that final 20 minutes, I'd like to open things up to questions for our panelists. Folks on Zoom, feel free to drop things in the chat if you'd like, or feel free to speak up. Same for anyone present. I'll be happy to run around the room. Clearly, I need the exercise anyway, and bring a microphone to you and back and forth. So feel free to just ask.
So if the court rules that the policy regarding the personality I forgot what it was called, personality points or something, finds that that is unconstitutional or the statutory interpretation is wrong or whatever, what will that look like going forward for these universities? Because as a Black woman, I don't see it boding well for everybody. So that was my question.
So I'm not totally, like, I think if it was a ruling just about that, I think it's a very marginal adjustment on Harvard's part. The issue, I think, is how you ever think about enforcement, which has been the awkward point of all of this, be it narrowly tailored or not used. Unfortunately, I think whatever it is, there's going to be another lawsuit, because I think it's very difficult to think about how enforcement for that would work.
I mean, I think how it would look is you know, I think we'll be moving backwards, and Professor McKeown had the point about, you know, admissions isn't the end, right? And maybe too often it's seen as we're dealing with the problem, and we're improving our diversity, and then if that's the end, it's you're failing some of your students. But I think it is a necessary first step, and I guess my fear, and I do appreciate the point that it could still be a narrow holding. You know, that's not necessarily what I predict. You know, what I fear, I guess, would be that it's a broad holding, and that it's a broad holding that goes beyond higher education, and that really affects the ability of the state, as well as anybody who receives funding from the federal government, to really address white supremacy, and to really just handcuff those who are out there that are seeking change, right, and are trying to make the communities better on the ground. I mean, that's kind of the worst case scenario, I think, is that there's a very broad holding that says, you know, any explicit mention of race is per se invalid, more or less. And I don't necessarily expect it to be quite that broad, but there's a whole, you know, infinity of of possibilities in between there. But just in the case of higher ed, I just see the ramifications as, and it depends on the institution, and you know, and all of that. But I just think the message from that would be so detrimental to the mission, and mention the academic freedom component of this as well, which I think it was just mentioned once, but it is an important component too, that this would be an attack on academic freedom, and setting, which also would be very detrimental to this environment. Yeah, so, you know, I think it does depend on the institution, to be sure, but I don't see anything positive coming from this.
So I should say, I may have misinterpreted the question. I thought the question was if we stopped what was going on with the personal score. But I actually don't want to make any predictions about what the Supreme Court's going to do just in my role in the case. I can just think more about responses to it than anything else.
That that race can be considered as a positive factor in some circumstances. And so a broad holding overturning the admissions policy means that their decisions are going to somehow have to be race neutral, or what the court would, what they're referring to as race neutral. And I think the implications are pretty, we all understand what the implications are. I mean, one of the things that hasn't been mentioned yet, but that was argued pretty vigorously in Grutter, and in fact, I believe the US military wrote a friend of the court brief on this issue in Grutter, and it was the idea that you have these elite institutions, you're training people who are literally going on to be Supreme Court justices and presidents and senators and all of this stuff. And you're training them in institutions where they are surrounded by people who look like them, who have the same life experience as them, who come from the same socioeconomic background as them, which means that they're not going to be very good leaders, right? Because they don't understand how the rest of society operates. And so one of the arguments that the military made in the Grutter case was that we need to have these policies to ensure that we are training future leaders who look like the population in the United States. And so I think there's going to, there's real risk, especially with these these elite institutions that are creating our government infrastructure, they risk looking whiter and whiter if for no reason than out of fear of loss, arguing reverse discrimination. It could be problematic. I think the concern is warranted.
So we have a question. Oh, did you have? Okay. So we have a question from Zoom. To paraphrase slightly, how much longer will affirmative action be needed? The question was specific, 100 years, 500 years, how long is it going to continue to be necessary?
I probably don't have the smartest response to this question. In Grutter versus Bollinger, Justice O'Connor famously wrote that perhaps in 25 years, we won't need these policies anymore. Well, we are. And we still have the same issues with systemic racism. Like how long do they need to be in place? Well, I mean, how long does it take to reverse literally an entire history of a country that was built on principles of racism? And so if we are not willing to consciously address systemic racism, then it's always going to be here, and these types of policies are always going to be necessary.
Yeah, I don't think that there's any evidence of anything being different in the last set of years. So when we think about that, the O'Connor comment is basically that there's convergence that's happening. Over the last set of years, there has not been convergence. We got convergence for a while, then I don't know the exact point at which it stopped, but frankly, with what happened with COVID, it's going to get worse before, if anything, much worse. Just because of the differences in the schooling opportunities that different groups had during COVID. So if the question is, will it ever, are there signs of convergence? At what point would we see that? Something else needs to change. And so I think we might all be in agreement, at least, that what we're currently doing now with the policies that we have is not not successful overall in leading to the convergence of a more equal nation. And then there's debates about how big of a role affirmative action plays in getting us to that point. You know, in my view, if you look at some of the stuff that's been shown to be most effective, which a guy who's now sort of disgraced for other reasons, but Roland Fryer has actually shown clear work on how to close achievement gaps through things like charter schools and such. So, you know, I think that there are ways to close these gaps. You know, I can definitely see the argument for affirmative action, but there is a part of me that thinks it's a big distraction given its focus on the elite schools and not seeing a ton of convergence as a result of it. I think it's a policy that makes people feel good, but leaves the bigger inequities unaddressed.
Yeah. I mean, I guess I think that question is probably mostly rhetorical, but you know, it has me thinking of Justice Roberts' opinion in Shelby County, which struck down the Voting Rights Act requirement for pre-certification in states, former states of the Confederacy, and his opinion was premised on notions that this was no longer necessary, this mechanism, and that basically we'd moved past racism. And Justice Ginsburg had a line, which I'm going to butcher probably, but basically it's equating Justice Roberts' opinion to having an umbrella and thinking it's no longer raining because you have the umbrella, and you take the umbrella away and it's raining, and I think that's been borne out in what we've seen in terms of voting restrictions. So you know, as to how long things are necessary, I you know, as long as they're necessary, right? And again, I keep coming back to this notion that this is some deviation from what would otherwise be an objective process that doesn't take account of race, and that's not the case. Admissions is always factored in race. It's just typically favored and still favors white folks, and affirmative action, among other things, is at least partially taking account of that. And until we redress those inequities, it's still necessary.
So while we're going up for the question, I do want to push back a little bit on that. I think affirmative action favors rich folks. Sorry, admissions favors rich folks. And then that has a strong white correlation. But, you know, the programs do give preferences for minority students, given the other factors of admissions. But you know, the reality is our educational system does prepare rich kids much better for college than it does poor kids. And that obviously disproportionately hits minority groups.
I just have a quick question. Hopefully it's a quick question. So I'm really interested in what you said about Brazil and how they approach, I guess, affirmative action in their country. With my limited knowledge of Brazil, and it is a largely mixed race country, so it's not hard for someone who is white presenting to go back through their ancestry and find, oh, I have a Black grandmother, you know, do I qualify for these, you know, different bumps? So just how would that model work in the United States, where we have such a binary racial model where you're either white, you're something other than white, or you're, Black or Native.
Yeah, I think that the way it currently works in admissions, from what I've seen in terms of how race gets classified both at Harvard and UNC, is that if you list that you're Black, then that's what's going to be your race, regardless of what else you put. So I mean, I think that there's been some stuff about, can you basically lie about it? Because, how is it ever going to be enforced? But fundamentally, there's sort of an ordering of the races in terms of which one you put down. And so Hispanic, not a race, but ethnicity, they're going to classify you as Hispanic if you're not Black, but you list Hispanic. And then Asian's going to be after that. But that's also where things get really tricky, because you're sort of making something that's not binary into something that is, with regard to the racial classifications.
All right, I'll pass it, I guess, briefly back to the panel. Do y'all have any final thoughts that you'd like to share in the last minute or so with our patient audience?
Just a quick plug for the fact that, as I would say that I'm the non-academic up here, from a practical standpoint, I think as a student myself, I think that what's disheartening about higher education is perhaps to the point of that if you look at the Supreme Court justices and where they went to school, they definitely get bumps themselves in lives for where they went. And to me, that's not what higher education was supposed to do. I call it the great equalizer, but at times I would bet, statistically speaking, that probably would be not proven out. So I'm not, if you look at what I went to 2 private institutions before coming to a public, and I think it feels really good to work at a public institution. The more that I see a lot of these different situations, it feels good. The problem is that it goes back to representation, whether it's at the Supreme Court, whether it's in your state, whether it's federal, all those things matter. And so if you don't have the same advantages because of where you went to school that others do, then I think this creates, which it does, a big issue for us going forward.
I don't think I have anything to add except for that, just this, like the Federalist Society has been working for literally decades to get the court that is currently in place. So if you are a person who's studying law or planning on studying law and thinking about that you have concerns about where we are in the federal judiciary, this is a long game, friends. So we have to be engaged on these issues, and we can't just be like upset about it the minute the court's decision comes down and then forget about it 15 minutes later. These things take time to address, and they also take the concerted energy of the constituency.
Yeah, shoot, I'll just sign on to both of the both of those statements, and I really have nothing to add to that. That was excellent.
I guess the only thing I would say is thanks very much for having me. What I really appreciate is having discussions like this. I think that it's often the case, in my experience, that we basically put a whole bunch of people that agree with each other on panels, and I don't think that's where we learn things. I think having discussion, fleshing out places where we agree or disagree, to me, it bothers me that in higher education, we tend to have moved more towards panels rather than debates in some sense. And I feel like what's nice about this panel is you get a bunch of different opinions on an important issue, and that we ought to be able to discuss these things in a manner that is respectful to everybody, and hopefully affirms the dignity of everybody, both the audience and the members. So I definitely just appreciate the opportunity to be here with you tonight.
Well, with that, I'd really like to thank our panelists for giving us so much of their time this evening, and for all of you for joining us this evening. I think this was an excellent panel, and I hope that everyone's able to enjoy the rest of their week. Although some of the topics and ideas we put forward were somber, I think that there are some positive things that we can pull out of everything that was talked about this evening. So thank you. Thank you so much, Peter.
Thanks for having me.